There's this huge contradiction right at the heart of the American story. We're a nation founded on this incredible promise of equality, but we spent centuries fighting over what that promise really means in practice. We're going to dive into that story today, a story of epic legal battles, incredible personal sacrifice, and the very real ongoing struggle to close that gap between our ideals and our reality.
And it really all boils down to this one single phrase. It's the bedrock ideal of the whole country. But ironically, it's also been at the center of our absolute deepest, most bitter conflicts. So how do you make sense of that? How do you square that beautiful promise with a reality that, for a huge chunk of American history, was the complete opposite?
Well, that conflict was captured perfectly on a city bus in Montgomery, Alabama. Now, you've probably heard that Rosa Parks, a seamstress, refused to give up her seat because she was just tired after a long day. But that's not the whole story, not by a long shot. She was an activist, and this was a deliberate, calculated act of defiance. Her arrest became the spark that lit a fire, kicking off a massive citywide boycott and turning a national debate into a deeply personal fight.
Okay, so this wasn't just a fight on the streets, right? It was also a massive battle fought in the courts. So that gets you thinking, what were the legal foundations for this movement? What were the constitutional tools at the very heart of this struggle?
The rallying cry was for civil rights. And this is a really important point to get. We often think of rights as protecting us from the government. But civil rights are different. They're about requiring the government to step in and protect you from being discriminated against by other people or private businesses. And this is the key, right here, the Equal Protection Clause of the 14th Amendment. Honestly, you could argue this is the single most important phrase in the entire constitutional fight for equality. It became the legal weapon, the main tool for challenging discriminatory laws all over the country.
So, with that powerful legal tool in their pocket, the battle for equality really kicks into high gear. And the African American civil rights movement was right at the epicenter, really paving the way for so many other groups that would follow in their footsteps.
Now, to really get what they were up against, you have to understand the two faces of segregation. First, you have de jure segregation. Think jure like jury or justice. It means by law. This is the stuff that was literally written into the law books, white and colored water fountains. Then you have de facto segregation. De facto just means in fact or in reality. This is the kind of separation that happens because of social and economic reasons, like where people can afford to live. The first big push, the initial assault, was against that de jure, by-the-book segregation.
And man, this timeline really shows you just how long and hard this fight was. We're talking more than half a century where separate but equal from that awful Plessy versus Ferguson case was the law of the land. It gave legal cover to segregation in every part of life. It took decades of people fighting in court, case after case, to finally knock that down with Brown v. Board of Education, which then opened the floodgates for those huge wins in the 60s.
And the Brown case wasn't just some dry legal debate. It was about real kids like Linda Brown in Topeka, Kansas. What's so interesting is that her segregated school wasn't a rundown shack. The facilities were pretty comparable to the white schools. And that was strategic. The NAACP picked her case specifically to ask the Supreme Court a really powerful question. Even if things are equal on paper, isn't the act of separating people by race inherently unequal? And the court's answer, unanimously, was a resounding yes.
So, riding that wave of momentum from the Brown decision, Congress passes the Civil Rights Act of 1964. And, wow, it was an absolute earthquake. This wasn't some tiny little law. It was a full-on, systematic takedown of the entire legal framework of segregation. Suddenly, hotels, restaurants, any public place couldn't discriminate. It went after job discrimination. And this is huge. It gave the federal government the muscle to sue schools that wouldn't desegregate. It totally changed the game.
And just 1 year later, another massive piece of the puzzle falls into place. Now think about this. The 15th Amendment gave black men the right to vote all the way back in 1870. But for almost 100 years, states had all these sneaky ways to get around it. Poll taxes, impossible literacy tests, you name it. The Voting Rights Act of 1965 was designed to just end it, to finally forcefully make the promise of the 15th Amendment a reality.
So what's really fascinating is how all of this created this huge ripple effect. The strategies, the legal wins from the fight for racial equality, it basically created a playbook, a blueprint for other groups who are also fighting their own battles against discrimination.
Take the women's rights movement. I mean, their fight started way back in 1848. But after they won the right to vote, things got a huge boost in the 1970s. And what were they using? That same Equal Protection Clause. For the first time in a case called Reed v. Reed, the Supreme Court used it to strike down a law based on gender discrimination.
It was a game changer.
At the same time, the very idea of who that 14th Amendment protected was getting bigger. And get this, in the exact same year as Brown v. Board, the Supreme Court heard a case argued by Latino lawyers for the very first time. And their ruling was a landmark. They said you can't just systematically exclude Mexican Americans from juries. That officially stretched the idea of civil rights beyond just a black and white issue.
But it's so important to remember that this whole story isn't a straight line of progress. There were major setbacks, and the Korematsu case, that was one of the absolute lowest points. The Supreme Court actually upheld the government forcing over 100,000 of its own citizens into internment camps just because of their Japanese ancestry. It's a chilling reminder of how fragile these rights can be. And it took more than 70 years for the court to finally, officially, say that this decision was wrong.
So, building on all these earlier fights, the struggle for civil rights just kept expanding, you know? It moved into new areas and brought even more groups under that umbrella of protection.
And that led to this whole cascade of new protections. The Americans with Disabilities Act completely transformed public spaces. Laws were passed to fight age discrimination at work. And then, much more recently, we've seen the fight extend to LGBTQ+ Americans, with those huge Supreme Court wins on marriage equality and, just a few years ago, protection from being fired simply for who you are.
This all leads us to maybe the most complex and honestly the most contested topic in the entire world of civil rights, and that's the question of affirmative action. How exactly do you fix the damage from centuries of discrimination?
So what is affirmative action really? Well, the core idea is that it's not enough to just give everyone an equal opportunity at the starting line. The goal is to create policies that help achieve more equal outcomes. It's a policy designed to actively push back against the lasting legacy of all that past discrimination.
And the whole legal battle over this really came to a head with the Bakke case. You have this guy, Alan Bakke. He's white, he applies to med school, gets rejected twice. Meanwhile, he sees that the school has a special program that set aside 16 spots for minority students, and some of them got in with lower scores than he had. So he sues. And his argument is basically, hey, this is reverse discrimination.
And the Supreme Court's decision here was tricky, super nuanced. On one hand, they actually sided with Bakke. They said, nope, you can't have rigid quotas. Setting aside a specific number of spots is unconstitutional. But, and this is a huge but, they also said that universities could consider race as one factor among many when deciding who to admit. The justification wasn't to fix past discrimination, but because having a diverse student body is a good thing for education itself.
But since that Bakke ruling, the court has gotten a lot stricter. In a 1995 case, they ruled that any program that classifies people by race, even if it's for a good reason, is automatically suspect. It has to be narrowly tailored to achieve some compelling government goal. And that legal language, that much higher bar, has significantly limited what affirmative action policies can do.
And that's where we're left, with this huge unresolved question that we are still grappling with today as a country. How do you fix the wrongs of the past without creating new problems in the present? It's all about fairness, legacy, and what equality really, truly means. And it just goes to show you, the promise of civil rights isn't some finished chapter in a history book. It's a story that's still being written right now.